Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. As you will be aware, this show is designed to help you seek some kind of guidance to any legal issues you have arising, and for me to provide you with direction with regards to those queries, either by providing an answer to your question or signposting you to alternative services which may be better suited to provide you with the information you require. You can participate in this show in one of two ways. You can ring directly into the studio on the landline number you find at the bottom of your screen. If you are doing that, then please do make sure that you mute any devices that you are listening to the show on and speak to me directly on your telephone device. Otherwise, the echo and the feedback from your call will prevent me from understanding what you're saying and addressing your query properly and promptly. If you do wish to participate in the show but don't want to speak to me live in the studio today, then that's absolutely fine also. We do provide a second number at the bottom of your screen, and that is a number that you can send your WhatsApp messages on. Again, if you are sending messages through, please make sure you provide sufficient detail for me to understand what your query is, so that I can provide you with the best possible advice I can do and the fullest advice I can to help you and guide you in respect of any issues arising. Please also make sure that you anonymise your questions. Do not identify any individuals within your question, and particularly if there are vulnerable questions, and be aware not to send information through of any ongoing investigations or certainly ongoing cases without making sure they are sufficiently anonymised, without being able to identify the parties involved. I do often get questions about the language in which questions can be presented. This is an English-speaking show, but if you do feel more comfortable presenting your question either live on air or in your message, then you may do so in the Urdu language, and I will translate that and provide an answer both in Urdu and for our English viewers to translate that so that everybody receives the information. Do also listen to any questions that have already been presented in the show. If your question is identical or similar, you may receive the question through another viewer, in which case don't present your question. If it's already been answered, it will give somebody else the opportunity to present something else, and for our viewers to be educated about what their options are if they are facing a similar scenario. I do thank you for taking the time to send those questions through. I do have a number already waiting for me, and as I promise each week, if I don't get round to your questions and you don't put them to Mr. Bulbulia, who appears on Tuesday with his legal advice show, then I will pick them up the following week on Monday and start with the questions that are waiting from the previous week and then work through in that order. You will now be aware that this show does get extremely busy, and it's not always possible for me to get through all of your questions during the evening. If you are wanting to increase your chances of your question being presented and answered, then please do get them in as early as possible. Certainly don't wait till the last few minutes of the show to try and call through and send that question in. So moving on to one of the first questions I have this evening. I have watched your video on YouTube regarding the Zambrano right to reside under the EUSS. I have made an application before 30 June 2021. I am a limited leave to remain holder under UK Appendix FM since 2019. And recently, I have read that the new Home Office Zambrano right to reside guidance, which was published on the 13th of June 2022, and it said that we are not Zambrano carer if we hold limited leave to remain under UK law. Is that right? That is right. So the new guidance that the Home Office published came on the back of some litigation and case law in which the courts found parts of the policy unlawful in the way the Secretary of State was implementing that policy. And so the Secretary of State, through the Home Office, agreed to review her policy and to set out a new policy which would address some of the concerns highlighted by the court. And in essence, what the Secretary of State has said is for individuals who have who already hold and who already have valid leave to remain in the United Kingdom, then they are not Zambrano carers. For anybody else, then they have extended the time frame, as I touched upon in my programme last week, to July to make those applications, and that will be seen as a reasonable excuse. So anybody that didn't manage to make that application prior to the 30th of June 2021 will then be able to make that application now. The Home Office will accept that application, and if the application is not made within that time frame, then the Home Office will want to see evidence for why an application is late, and whether or not there are exceptional circumstances, which are again defined within the guidance. It can't be any kind of circumstances. There is a list of things that the Home Office will consider exceptional to allow that extension. So you are right that the Home Office has made that policy that says if you are a holder of limited leave to remain, then you do not qualify under the Zambrano carer route. You have an open case. Your case won't automatically drop away. The issue that you will now face is that the Home Office is likely to reject your application as a Zambrano carer, and you will then remain on the route to settlement through the limited leave to remain that you already hold. You say that you've had leave since 2019. You will be due to extend your leave any time now. Now, I have again touched upon this in previous shows. There is a manner in which you can reduce the time in which you achieve settlement, and that is by transferring yourself from the 10-year route to settlement to the 5-year route to settlement. And the way you do that is to ensure that you meet the requirements under the 5-year route. The distinction being the English language test, so you will need an English language proficiency test at the required level, and you will also need to meet the financial requirements. But now that you have limited leave to remain already with the right to work, then it's a lot more likely that you can do that. What you can then do is, instead of extending directly into the 10-year route and continuing through that route, you can vary your application into the 5-year route. And that essentially then means that even though your 5 years would start when you are granted your extension, you would then fall into the 5-year route. And so after another period of extension and completing those 5 years, you would then be eligible for indefinite leave to remain at the 7.5-year mark rather than the 10-year mark. So do look into that also. Furthermore, if you have children who are in the United Kingdom, who are also dependent on you on this 10-year route to settlement, if they were born in the UK, they have been here for a period of 7 years, then you can apply for, the children can apply for indefinite leave to remain upon that qualifying period of 7 years. They don't need to continue onto the 10-year route. If your children were not born in the United Kingdom but have been here for the qualifying period, then they can apply to go into the 5-year route as well. And that's part of the new private life, family life policy. So there are various things you can do to speed up your own settlement route, but also to either settle your children sooner or to speed up their route to settlement as well. So do seek legal advice. Make sure you are on the best possible route. You have explored all of your options. Don't simply just renew your application, because that's longer, it's more expensive, and so you miss out on those opportunities. And thank you so much for your du'as at the end of your message. We do have a brother on the line, so inshallah we'll proceed to take his call. Hello, assalamu alaikum. Assalamu alaikum, brother, can you hear me?
Sorry, assalamu alaikum.
Alaikum assalam.
Yeah, I have just one question for you. Is because I'm in the UK and I have a spouse visa, and my visa is going to expire in this September. So I just want to know and confirm it. Do I need to hire the solicitor to submit my documents, or I can online submit everything? And how many days before I can submit this visa application?
So your visa application, brother, you can submit up to 28 days before your leave expires. So that's how long before. With regards to should you hire a solicitor, there's absolutely no necessity for you to do that. What I always advocate for is the best legal advice and early legal advice to avoid any pitfalls. If you feel confident enough to do your application yourself, what I might suggest is you prepare the application and then maybe access a visa check-in service. Some solicitors provide that service. And what they can then do is, rather than preparing the full application and charging you for that, they can look through your prepared application, the documents that you've collated to submit to the Home Office, and advise you whether there's anything missing or whether you have met all of the requirements. So that may be an option for you, but there's absolutely no necessity. There's nothing that says you must submit the application through a solicitor or through a legal representative. If you're confident enough to do that, you can do that yourself.
Yeah, thank you very much. Because I checked all of the requirements, what they needed on the government website.
Yes.
But I didn't find out the date, how many days before I can submit the visa application. And can you please tell me how long it take for give me the visa extension?
So you have a number of options. At the moment, applications the Home Office is advising up to 8 weeks. You do have the option of the super priority service if that's available when you submit your application, and you would then have a decision within 1 working day. But you would have to pay an extra £800 for that service. But otherwise, at the moment, the time frame say up to 8 weeks. It might be slightly longer because of the delays, but roughly that's what the Home Office is saying on their website at this stage.
But my question is, because I'm in the UK,
Yes.
I don't need it to go to the, the fast forward way.
Yes.
And my visa, because you just say I need to submit it before the 28 days before. And if they will take that 8 weeks, so it will affect my visa, or I need to stop everything, or what's there?
No, brother, it has. What I will do is we are proceeding to a short break, and I'm sorry it's come at an inconvenient time. If you stay on the line, I will continue to answer your questions after this break. Inshallah, join me then. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum and welcome back to the second segment of the free legal advice show on British Muslim TV. My name is Riffat Hussain and I am your host this evening. Just before we went into the break, we had a brother on the line asking some questions in relation to an application he's seeking to make later in autumn. We unfortunately did need to proceed to a break, and I believe the brother's call may have dropped. Inshallah, if brother, you do have any further questions, feel free to call back. If you don't, then I hope the answers I've provided do provide you with the assistance that you require, and the best of luck with that application. Inshallah, in the meantime, I will move on to some other questions. So my next question is, my son is a British citizen and married recently overseas. I want to bring my daughter to the UK. Will she apply for the visa in Pakistan, or will my son apply here in the UK? So the application for entry clearance for UK immigration, be that a spouse or in any other category, is made online. So the individual's location doesn't necessarily matter because it's done on the computer. So your son can prepare the application here, or your daughter can prepare the application overseas if she's able to do that and has access to the computer. The application will be submitted fully online and paid for online as well in the local currency. So if your son makes the application here in the United Kingdom, then he will then proceed to make the payment here from the United Kingdom using his credit or debit card, but it will be in Pakistani rupees or the foreign currency that your daughter-in-law's country implements. So that's how the application is made. And it is fairly self-explanatory in terms of you will follow the screen through. Just make sure you're answering all the questions fully, and then you will get a document checklist at the end. Do refer back to the Home Office guidance to make sure that you have covered everything properly and that it is in the right format. It's extremely important that you are submitting documents in the correct format for the right time periods with the correct information in there. But in answer to your question, online application, location doesn't matter in respect of that. Moving on to our next question. Slightly lengthy, so do bear with me. My question is about family law, which is as follows. I'm a single parent of an 8-year-old child who lives with me and sees their other parent, lives with me full-time, as I have got a full residency order from the court, but she also sees the other parent once a week due to the court allowing this. My question is, if I need to go abroad, do I still need a court order to remove the child from the UK to another country for holidays? What is the legal age that my child can come abroad without requiring a court order or the other parent's consent? Secondly, with regards to contact, when my child is going to be 16, can they decide whether or not they want to see the other parent, how often, and will a new court order be in place? So a number of issues there. So with regards to whether or not you need a court order to take your child overseas will depend on your circumstances. There may be something already in the existing court order which stipulates whether or not you can take this child overseas. It may say that you can take your child overseas with the consent of the other parent. If the order is silent on the issues, then you may wish to clarify that with the court before taking steps to remove your child from the United Kingdom, even for a holiday. If you have an allocated social worker, they may have some further details as to what you can and cannot do with regards to your child's overseas trips. So they're the places where you would check. Always err on the side of caution. You don't want to fall foul of court orders and court rulings, particularly where there are young children involved and there's already issues around contact and residency. So if you're unsure, clarify with the right people, clarify with any social workers, clarify with the courts, make sure any clarifications are in writing so that you have that evidence should you be provided the wrong advice initially and that is known to have happened. Usually court orders are in force until the child is 16 years of age, unless there are exceptional circumstances. So it's not a blanket at 16 that court order falls away. There are exceptional circumstances, and again, you need to be satisfied that your child does not fall within those exceptional circumstances, and thus the order then extends into their 17 and 18 years also. So I hope that answers your question, but 16 is the age where the child is usually able to make those decisions, is usually the age where those court orders will end, but do check your personal circumstances. That's just generic advice, and that's what usually happens. But there are always exceptions to the rule. Next question. I'm going to apply for my wife's extension on the 5-year route. I'm employed and have also started self-employment recently. What documents do I need to provide? Well, with regards to an extension application, that you would need to look at the guidance in terms of the documents that you are providing. You need to evidence your income for a period of 6 months, so the period of 12 months prior. So you need to meet the requirement for that period of time. And usually you are required to provide 6 months worth of, for instance, wage slips and bank statements to evidence that your average income will meet the required threshold. If you are employed and self-employed, then there are additional documents that you will require. The only issue with self-employment is usually the Home Office will require information for the previous financial year. So if you are applying in the current financial year, the Home Office is looking for evidence for the financial year that has passed, ending the 4th of April 2022. So that may present difficulty in terms of your recent self-employment. I'm not entirely sure why you're needing to evidence both of the incomes. Is it because your employment doesn't meet the threshold, or is it just because you want to account for all of your income? But in those circumstances, I would advise seek legal advice, particularly if you are falling under the threshold for the extension. Look at your options in that way and how your self-employment can help, because there'll be a lot of things that you can't evidence at this stage. You won't have your accounts, your self-assessment accounts. You won't have the statements from the HMRC. You will have your unique tax reference number, which is one of the documents that are required. So in terms of self-employment, you are limited at this stage as to what you can provide in any event. And as I've said, the Home Office usually, and the rules require evidence from the previous year, not the current year. So again, you need to be looking at the employment, whether or not you meet the threshold. And if you don't meet the threshold, then seek that early legal advice as to what your options are and how you can try and remedy this before reaching that deadline to extend your wife's stay. I hope that provides you with some clarity as to how you can proceed with that matter. Another question. I have just recently got married, again overseas. I wanted to bring my wife over here in England. So I just wanted to know what I will need to do in order to bring her here. So please let me know. Thank you. And thank you for your question. A similar question I answered earlier. That kind of talked about the procedure of making an application. So the application is prepared online, is submitted online, the payments for the application are made online, and then your wife will simply need to book an appointment. And again, that's done through the online system for the local visa application centre, and take her passport and her and enroll her biometrics. So that's the way that application process works. With regards to what documents do you need, well, it's a marriage, so you need a marriage certificate to establish that the marriage has taken place. The immigration rules also require that both parties have met each other. So any evidence to show that you will, of course, travelled overseas to go and get married. There'll be photographs from the marriage itself. So, things of those nature. A TB test, if your wife is from a country where a TB test is required from, I can see from your question that it will be. English language is another requirement to level A1, and that needs to be completed before you make the application. Evidence that this is a genuine subsisting relationship, so evidence of any contact that you have between yourselves, any kind of money transfers if you're financially supporting your wife, anything that persuades the Home Office that this is a genuine relationship. Both of you intend to live in this marriage as husband and wife. And then the financial requirements are a key part of these applications. If it is just your wife that you're applying for and there are no other dependents that you have who are not settled or British citizens, then the threshold is 18,600. There are a number of ways you can evidence that, so either through employment or self-employment, or through a non-employed income. So you may have rental properties that generate an income. There are various ways of doing that. And each category has its own set of requirements as to what documents are needed to evidence the income threshold. Bank statements, wage slips if you are employed. The exception to the 18,600 is if you are in receipt of any disability-related benefits, so personal independence payments, disability living allowance, or even carer's allowance exempts you from the 18,600 threshold. That doesn't mean that there isn't a financial requirement. It's just a different test. So again, if your circumstances are different, then please do seek that legal advice. And finally, accommodation. Is there adequate accommodation for you and your wife to live in when she arrives in the United Kingdom? So they're the documents that you need. I hope that provides you with the help that you need. And best of luck with that application. Inshallah, it all goes well. We are now approaching the second break of this program. Do continue to send your question through. Inshallah, we'll be back shortly. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum and welcome back to the third segment of the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Just before we went to the break, I was able to answer some of the questions put to me on various topics, mainly immigration, but also some family law issues in there. I hope that I have been able to provide guidance and provide some kind of relief from the worry of not knowing what to do and which direction to look in. If you do find yourself in that situation, please do send your questions through. I will do my absolute best to provide you with an answer. And if I can't, then at least some kind of guidance as to where you can look or how you can get that help, so you're not left just worrying and not knowing how to resolve your query. Moving on to another question that I have. So I got a family visa last year. I have 4 children and came to the UK in 2012. My youngest child was born in the United Kingdom and is now 9 years old. The oldest is 16 years old. Need your advice, thank you. So with regards to your question, it's slightly ambiguous in the sense that you've already got the visa, so I'm not entirely sure what the question is. There's a couple of things that I can pick up from it, however. You have a child who was born in the United Kingdom and is now 9 years old. Now, if that child is on this 10-year route to settlement with you, then you may be asking me about this new policy where a child who has attained 7 years in the United Kingdom can apply for indefinite leave to remain outright. And so you have that option. You have the option of varying the application and applying for your child for indefinite leave to remain. Now, alternatively, I know that your child is 9 and your question doesn't really tell me when they turn 10. But once your child has been in the United Kingdom for 10 years, then they can apply for registration as a British citizen. And you may have heard me recently talk in the last few weeks about the fee waiver policy for children who qualify to register as British citizens. And so what you may wish to do is, instead of looking to apply for indefinite leave to remain now because your family are secure and you all have leave to remain in the United Kingdom, is wait the few months that you have before your child turns 10 and then apply for a fee waiver if you can't afford to pay the fees and qualify for the fee waiver, and apply for your child to then be registered as a British citizen. And that would probably be the best option for you. Once you've done that, what you might also want to do, or you might want to do it at the same time, it's entirely up to you, is look to make discretionary applications for registration for your other children to register as British citizens. So that looks like the best option for your children. With regards to your options then, you remain on the route that you are on. I'm assuming that's a 10-year route for now. You use this period to improve your financial circumstances and to improve your English language if it needs improving, and to get the relevant certificates to demonstrate your proficiency in the language. And then at your renewal date, then vary your application into the 5-year route so that you are then on the 5-year route to settlement rather than the longer 10-year route. So I hope that helps with your query, but you may want to be looking at registration as British citizens for your children as the option for you, rather than the route for quicker settlement to indefinite leave to remain. Again, seek further legal advice if you're unsure, but that's probably the direction you need to be going in. We have a brother on the line with a question, so inshallah I will take his call. Hello, assalamu alaikum. Assalamu alaikum, brother, can you hear me?
Wa alaikum assalam, sister. Yes, I can hear you. And thanks for taking my call.
My pleasure.
Right, okay. Basically, I need to ask you one question from a friend.
Sure.
He is here for 19 years.
Mm-hmm.
He is obviously legal status is not. But he got proof of everything, like address, bank statements, everything.
Yeah.
So being 19 years here,
Mm-hmm.
I am looking for some of your advice on it. That what you recommend, that he will wait for another year, or he will put some sort of application in the process.
So it's a difficult one because I can't advise your friend to remain in the United Kingdom unlawfully. And so if he does remain in the United Kingdom without making an application, then that's essentially what he's doing. When you say he's been here for 19 years, when did he arrive?
I, to be honest, don't remember the date.
Right.
But
okay.
I know only that he's up till about 19 years now.
Okay. I mean, I suppose in respect of your question, what you're alluding to is the 20-year stage for private life applications. And so these are applications where an individual can demonstrate that they have been in the United Kingdom for a period of 20 years, and that is evidence through documents. They can then make an application to the Home Office based on their private life, because they would then meet the immigration rules. But you can't make that application until you have achieved the 20 years. So don't make it before, even if you've got 19 years and 28 days.
11 months, even then you can't wait.
Yeah, exactly. It's not enough. So once you've completed the 20 years, then at that point, you make the application with the evidence. Now, there's a trap that a lot of people do fall into. So when people originally arrive in the United Kingdom, they have very little evidence of what they're doing. And so there's usually a gap between the date of arrival and the date that they start accruing evidence.
Okay.
And what people forget is that they will still need evidence. So, for example, if your friend arrived in 2012, 2002, my maths isn't brilliant, in 2002, that he would now be approaching the 20-year mark. Now, if in 2002 he came and he did nothing for 10 months, 12 months, and there's no evidence, apart from the stamp in his passport that says he's come, there's nothing in his passport that says he was actually here in that year. Now, with these applications, the Home Office will consider the evidence. And so if you submit the evidence to say your friend arrived in 2002, but the evidence actually starts from 2004, they will take the 2004 date. So he's then lost 2 years and he hasn't achieved the full 20 years.
Okay, I get that, but sorry to interrupt you on it.
That's okay.
So so basically what is the evidence? Okay, one evidence is when you arrived, overseas stamped passport, and the second can be your bank statement.
Yeah, I mean, it's difficult, isn't it? Because if you're unlawfully in this country, then you're not going to have a lot of evidence. It's not like you've gone to work every day, or that you've claimed benefits, or you've paid into HMRC.
Yeah, obviously you can't claim benefit anyway. So
yeah.
No, that's the thing. Basically, he is, I think, working as well. But to be honest, I don't know.
Yeah. And there are individuals that do that. There are individuals who are living a life as if they were lawfully here. They go to work regularly, they pay their taxes, they access public services. And for some strange reason, they've never had that status to do that. So it may be that your friend does. And bear in mind that the checks and the rules weren't as rigorous and as strict in the past. So even though there are those restrictions now with right to rent and right to work checks, they didn't exist in the past. And so people have been able to live a relatively normal life and accrue that evidence. But if there are any gaps in the evidence, so for example, if there's records for 18 years to say your friend's been working, but then there aren't the other 2 years, look at other evidence. So was he registered at a GP? Was he receiving any kind of medical interventions?
Yeah, and that he got all.
Yeah.
When he arrived, he registered with the doctor, and then I think he stayed with the same doctor and the son.
Yeah, absolutely. But also, you might know people in the community. There might be people, respected members of the community or professionals who are able to confirm that they've known that individual from the community for all that period of time. So there's other imaginative ways that you can get this evidence together. But yeah, full 20 years before any application can be made in that category.
Right. Okay. But I thought, to be honest, you can process that. I mean, I haven't physically discussed myself with someone, but somebody was suggesting that you can actually process your application, but you have to go on 5 years sort of thing. First you will get 2-year visa or something, and then 3 years sort of thing. Not
that I'm aware of. And as I say, if you don't meet the rules, then you don't get anything.
Okay. No, I get it. Okay. Thank you. Thanks a lot for.
Thank you so much for your question, brother. Thank you.
Thank you. Okay. Jazakallah khair.
Barakallah feek. Thank you so much. Right, so that's a question from our brother. We do have another brother on the line. Inshallah, I will start to take his question. We are shortly due to go to a break, so I may need to save my answer till after the break. We'll see how we get on with the time that we have. Hello, assalamu alaikum.
Hello, assalamu alaikum.
Alaikum assalam.
Am I speaking to the live show?
You are, brother. Yes, please go ahead.
Okay, so basically, recently I've been granted ILR on the basis of a carer of a British citizen. My dad is a British citizen. Mm-hmm. So I've been granted ILR on the basis of Zambrano principle. Mm-hmm. I've checked on internet that I can apply for my British passport after 1 year.
That's right.
Obviously, it says I can be out of the country for 90 days maximum in a year time.
Yes.
So I just wanted to know, these 90 days, it starts from the day of my ILR to, like, for example, if it is granted on 10th of June, so in next year, 10th of June, is that where they count it, or is it they count it in a yearly basis, like 2021 or 22, 23? Which basis they count this 90 days?
So they will count the year from the date of your application. So if you make the application on the 1st of June 2023, they will count back a year from that date. So it's the previous 12 months from the date of your application.
Sorry, I didn't quite understand you.
So
this 90 days, this 90 days gap is only accepted if I be out of the country. And
yes.
If I'm out of the country more than 90 days, then I cannot apply for British naturalization, isn't it?
Well, you can apply. Yeah, you can apply, brother, but it will be rejected. Brother, we are just going to our final break of the evening. Inshallah, stay on the line, and inshallah, I'll pick this up after we return from this break. Join us then. Assalamu alaikum. Assalamu alaikum and welcome back to the final segment of the Free Legal Advice Show on British Muslim TV. Alhamdulillah, we've had a lot of questions coming through today, particularly into the studio. Please do keep those questions coming through. I'm so sorry, the brother that was on before the break, your call has dropped. Inshallah, please do ring back and I will pick up your query. I do have to go to the breaks as they are scheduled, unfortunately, so I couldn't keep you on any longer at that point. Whilst I'm waiting for you to come back, inshallah, I will take another question that's come through on the WhatsApp group. So this question is, I'd like to ask a question. I have a residence permit. I have to renew my residence permit at the end of July this year. Can you please tell me how much the Home Office fee and medical, and also how much the solicitors charging their fee? Jazakallah khair for your question. Unfortunately, you haven't told me which category you're extending in, and the fees change depending on that. So if you are applying, for example, as a spouse, or on the partner route, and that's in country, and you're on the 2.5-year extension, then you will be paying £1,560 for the immigration surcharge, and an additional £1,048 for the actual application fee. So that's the Home Office side. On the partner route, I'm going to make that assumption. That's where most of the extensions come in. If I am wrong, then please do forgive me and do correct me. With regards to costs for solicitors, now what you have at the moment is you have two systems. You have qualified solicitors who are qualified lawyers, essentially, what we traditionally think of as lawyers who have gone through law school, got their degrees and gone through that route and have qualified, and they are often regulated by the Solicitors Regulation Authority. Now, if you have a solicitor, then they are required through the transparency arrangements at the Solicitors Regulation Authority to publish their prices. So you can go onto any law firm's website, and if they practice immigration law, you will be able to go to a relevant section and you will be able to see exactly how much they are charging you. And that has to be there. And you are, solicitors, we are required to provide that information. What you also have is what are called legal representatives, and they can use the term lawyer, but not solicitor. So if you have a lawyer, they're not regulated by the Solicitors Regulation Authority, then they're not a qualified solicitor. They're usually regulated by the OISC. And I don't believe that the OISC has similar arrangements to the Solicitors Regulation Authority. So they're not required to publish prices. With an extension, you're looking at prices around the 400, 500, 600 mark. Some will charge you more. I suspect if anybody's charging you less, then you need to question why. But you're probably in the right ballpark if you're in that bracket there. It will depend on the complexity of your case. So if your case is particularly complex, then you may find that you are having to pay a higher price. But with any qualified solicitor, they will discuss that pricing with you at the outset. They will explain if there is a complexity in your case, why they are needing to charge you more. And often, most solicitors that I know will provide you with a fixed fee or an agreed fee price at the start. So you will be told how much you're going to pay, and that is all you will pay. And again, you'll find that if you're not being given that, you probably need to question why that is. And the costs may then increase as you go along. So they may seem quite competitive at the start. They may not be as competitive once you've started your case. So I hope that provides you with the information you require. Inshallah, best of luck with that application. And if you do need any further clarity, if I'm completely off the mark and that's not the application you're applying for and they're not the fees that are applicable, then inshallah send me another message through. Or just pick up the phone and speak to me, and I'll clarify that for you. So that's in terms of that question. And it can be really daunting to try and go out and seek legal advice. There are a lot of misconceptions, and I, as a lawyer, often find one of two problems. The first problem is people haven't actually sought legal advice because they thought it was going to be far too expensive to do that. And there is this misconception that if you go to a solicitor, you're going to be paying thousands and thousands and thousands of pounds. That's not correct. You will find that we are competitive, we are fair in our pricing, and we are upfront more than anything else, we will be able to say, this is how much you're going to be paying, this is what you're paying for. Hopefully it comes across with the information you get both from myself and Mr. Ilyas Bulbulia, that when you do seek that legal advice, there may be other options that are open to you. There may be a quicker route to settlement. There may be a different route to citizenship. There may be different routes for your family members. For example, a questioner earlier wanted options on to how to settle their children in terms of indefinite leave to remain. Absolutely, they can do that, but they have a better option, which is to apply for registration as British citizens for their children. So you bypass that. And in the process, you do save thousands. You save the thousands by not having to make that additional application. You save thousands by not needing to make that additional application, for example, for indefinite leave to remain before you apply for the registration as a British citizen. So and so do get that legal advice. We're not as scary as it initially seems. And you will benefit from good early legal advice. You know, so do get that in there. With regards to the other problem that us lawyers often see and as solicitors often see is when people come to us after the problem's been created. There's and we get more of these than you know, people coming to us in initial stages. We often get people having made their own applications because they thought that they were confident enough to do that. It's gone wrong. The consequences can be quite serious. We also get a lot of people coming to us and saying, well, my friend told me to do this. My friend did this. My neighbour did this. It might have worked for them. It might have worked for them because they just happened to get lucky. It might have worked for them because their circumstances were different, even though on the surface they appear to be the same. Trying to put something right is harder than getting it right in the first place. And as they say, prevention is better than cure. And that absolutely applies to your legal issues. You wouldn't self-medicate. You know, you wouldn't try and treat serious illnesses and then go to the doctor once you've decided that it hasn't worked. Although, again, I've known that to happen in the community as well. But, you know, be careful. Be careful what you're setting yourself up for. Because if you are going to be losing 7.5 years worth of lawful residence, you know, 9 years of lawful residence, there is no way, irrespective of how good your solicitor is thereafter, that they can replace that for you. They might be able to make sure you're not leaving the country, but they're not going to be able to reinstate your past immigration history. And so, you know, there's only so much lawyers can do. We may be good, we may not be good, but we're certainly not miracle workers. So do think of that, please, when you are considering your personal circumstances. Yes, you might be saving a little bit now, but what are the consequences, both financially, but more importantly with your future and the future of your family and your children? So the questioner has come back with regards to that last question. The extension is a human rights extension, and just touching on that point, because I have seen this recently. So human rights application, those are the right fees. So 1,048 per applicant. So if you've got, for example, mum, dad and children, it's 1,048 per applicant plus 1,560 per applicant for that human rights application. You will have heard me speak about fee waiver applications in the past if you're unable to meet the application fees. And again, that's something that you can seek legal advice on. We are in the final few moments of this show. So I'm just going to try and get as much information as I can out. The terminology that you use in the question, and this isn't a criticism, this is something that we saw in terms of a live case. So we had a case, again, where things had gone wrong for this individual. And the same question had been put to them. they thought they were applying for a residence permit in the category that they were in, because their residence permit was coming to an end. The individual then went online and applied for a new residence permit. The residence permit is just your ID card, and so you can replace that or renew that if it expires, but it doesn't give you the visa. This individual then became an overstayer because they applied in the wrong category. They'd applied for just a replacement card, which they weren't going to get because their visa had just expired. And then they were an overstayer, unable to work, unable to rent, unable to claim benefits, and the consequences of that, as well as losing their lawful residence and having to wait the 10 to 12 months for the Home Office to then decide whether they could have a new visa. So please be careful. That brings us to the final minute of this show. I'm absolutely humbled by your support this evening. Please do keep those questions coming through. And inshallah, I will be back next week on Monday, 7 p.m. Our brother Ilyas Bulbulia will be here tomorrow, 8 p.m. So if there's anything you've not been able to send through to me, send that through today and tomorrow, or speak to him in the studio from 8 o'clock. And Jazakallah khair. It's really appreciated. And that leaves me finally to say, keep well, keep safe, do send your questions through, and inshallah I will be back at the usual time next week. Join me then on the Free Legal Advice Show. Assalamu alaikum wa rahmatullahi wa barakatuh.